welcome. We are starting our third program under the AACE Brazil and DRBF LATAM Awareness Program. Thank you very much for attending today. This is part of a program of 8 webinars, whereby we'll be talking about dispute board related matters. The idea being always to have somebody from the DRBF region number 1, meaning the United States, and bring their knowledge and expertise and share it with other people from different regions of the world, especially people in Latin America. We are also always in these webinars counting on a representative from DRBF region number 4, that's LATAM, and a host from the AACE Brazil section. So today I want to thank very much, and as always, Anne Russo and the DRBF for being part of this. Very important, and this is all they do, dispute boards. So we are talking to the best ones in the market to help us put together this program. Also, thank you very much, Kurt Detman, a great specialist who I met not that long ago, was very generous to accept being part of this program, and he'll be talking today about partnering, something that in my experience at least is very new across Latin America. And we also will count with Julio Cesar Bueno, an expert lawyer, construction lawyer from Brazil, but also acting all over the world. And will be very interesting to have their presence and inputs across the board. So without further ado, I'll leave it to you, Kurt. Please go ahead and start your presentation. If people have any questions, as we mentioned before, please go ahead and send them through the questions and answers box. If you want to say hi, please do that through the webinar chat. With you, Kurt.
Okay, thanks very much, Felipe, and thank you, Julio, for joining as well. So I'm going to talk about partnering in the United States. So one thing I wanted to emphasize, and I want you to keep this in mind as we go through the webinar today, is that I'm talking about the use of partnering and dispute review boards in the United States. And there's a reason why I'm using the term dispute review boards, because in the United States, we have our own version of it, which I'll go through and compare that against what is partnering. So let's start with some basics. What is partnering? Typically, partnering is set up in the contract with a partnering provision. It's usually pretty short, and it basically says, we are going to partner. We're going to do the following basic things, and we're going to have the contractor and the owner commit to partnering. But one of the very important things that owners always say over and over again, partnering does not change the contract terms. The contract terms continue to apply. Partnering is a tool that is included in the contract to be used as part of project management. So generally, the term partnering, as used in the United States, is a commitment by all parties to collaborate and cooperate in managing a project. Now, one might wonder, why do you have to tell people to get along with each other? Well, there is a debate in some places that says, why do you need to tell people to partner? But what we have found over the years is having it as part of the contract, where it's a contractual commitment, assists in making sure that collaboration and cooperation is part of the management of the project. Now, there are 2 types of partnering. There's informal partnering and formal partnering. Today, I'm going to primarily concentrate on formal partnering because that's the closest cousin, if you will, to the dispute review board process. But there is informal partnering where, again, the contract will say, we are going to partner, but informal partnering is just that. It basically is a commitment by the 2 parties to collaborate with each other. And although they may use some of the partnering techniques, it's not as formal as formal partnering, which I'm going to describe. So what is formal partnering? Typically, formal partnering is done by hiring a third-party partnering facilitator at the beginning of the project. It's a split cost, 50-50. The owner and the contractor each pay 50% of the cost of the partnering facilitator. There's a partnering kickoff session that usually happens 60 to 90 days after notice to proceed on the contract, and it includes the following. It results in a partnering charter with goals and metrics, and literally the partnering charter is a 1-pager where everybody signs it, and there are certain goals of the project. For example, finish on time, finish within budget. There can be a goal of the contractor making money. There can be a commitment to safety. Those are the kind of things that you'll find in a charter, and then metrics to measure whether that's being met. There's usually a lot of time spent on identifying project risks and mitigation strategies. What are the biggest challenges of the project, and what is the team going to do to try to address those? So, for example, if it's an underground project, one of the risks will be differing site conditions, and there will be some discussion about how do we mitigate the potential effect of hitting a differing site condition while we're in the process of tunneling through rock or some other material. There's also a discussion about project communications and decision-making protocols. So how are decisions going to get made? Who reports to whom? Who can call whom? Where are the dotted lines on the organization chart? Where are the solid lines on the organization chart? Those kind of discussions. And then finally, they result in a issue escalation ladder, an agreement that certain issues will be resolved at the project level, certain issues can be bumped up to the middle management level, certain issues can be jumped up to the senior executive level. And a lot of times they'll have time frames on that. It'll say within 10 days, within 14 days, within 15 days. Now, this is in addition to any official notice requirements under the contract. So it's basically a management overlay of how we're going to execute what the contract says. Then there'll be a partnering maintenance plan. What happens after the kickoff meeting? These are typically reconnects of the project team, getting back together again, either every 4 months or every 6 months, or maybe every year. Typically, it's about every 6 months. Subject matter task forces if they're needed. So if there's some particular area which could not be resolved in the kickoff meeting, a small group can be put together to come up with a plan to deal with that. So-called project health checks, which are generally surveys that are sent out to the team, going back to the project charter and saying, how are we doing? Are we doing well on communications? Are we doing well on decision making? Are we doing well on schedule challenges? And then also you can have interventions. If there's a problem on the project where the project is not advancing how it should be, there can be an intervention, meaning a special partnering session where the partnering facilitator can be brought in. I'm on a project right now where the project was trending about 9 to 12 months late, and the decision was made to bring me in to have a workshop on potential schedule mitigation techniques. So that's an example of an intervention where there is some delay on the project. Now, the partnering process elements are encouraging a collaborative approach to project management, basically meaning you have to work as a team rather than individual players. There's a broad scope. It applies to all aspects and all levels of the project. So partnering can reach down to the field level. Partnering can be in the middle management level. Partnering can be at the senior executive level. And when I say all aspects, I mean all aspects. Let's say, for example, there's some conflict between the two project managers. A partnering facilitator can come in and say, we have a conflict issue between two people on the project. So a partnering facilitator can work on that. That's all aspects, all management aspects of the project. It also provides informal lines of communication. If there's a problem, you can call the partnering facilitator. Likewise, the partnering facilitator can talk to individual people, individual subcontractors. So for example, in the recent partnering intervention I mentioned, I was authorized to speak directly to a third-tier supplier and a major subcontractor to find out what they could do to help mitigate the risk. So this was me going down into the lower reaches of the project, so to speak, and talking to people offline, confidentially, to get their perspective on things. It builds trust in the project, and what we try to promote is what we call project first thinking. What is in the interest of the project first? What is in my interest as a, let's say, corporate player or an owner? and then what is my interest as an individual. A lot of times you'll see project teams starting with individuals, then looking at the corporate interest, and then looking at the project interest. So this tries to turn it on its head and have people think about the project as being the primary focus. It's a conflict management tool. If there's conflict between people, between layers, between levels, between outside stakeholders, the partnering facilitator can be brought in. And it can also be used as part of the dispute avoidance and dispute resolution process. One example is Caltrans, which is one of our major owner organizations here in the United States, has something called facilitated dispute resolution. So the partnering facilitator can actually be brought in after the DRB has given a recommendation, so that they're playing a role up front to try to prevent the dispute and on the back end to try to resolve the dispute. Now let's compare that to a dispute review board. Again, remember, we're talking about the US version. So in the US version, the specification defines the jurisdiction of the dispute review board, which could be limited. There could be a specification that says the DRB can deal with commercial issues. The DRB can deal with cost issues. The DRB can deal with entitlement issues, or it can only deal with entitlement issues and not cost and not time. So it may limit its jurisdiction. And the specification defines the process steps, appointed at the beginning of the project and remains in place for the duration, assists in dispute avoidance using regular meetings and advisory opinions, and assists in dispute resolution via the hearing process. So what we're trying to do here is set up the DRB process as compared with the partnering process. And you'll see there's a lot of similarity, but one of the things I want you to notice here is that the partnering scope is very broad and very high and low, whereas the DRB scope is usually circumscribed to deal with primarily the owner-contractor interface and with specific disputes that come up through a process with steps, communication protocols, requirements, and limitations. So if we compare them side by side, I'm just going to go down these bullets on the left and then the right to sort of compare the two against each other. Partnering is attempting to build trust on all project management issues, whatever they are. The dispute board is primarily focused on avoiding disputes under the contract where somebody is asking for additional scope, additional time, and additional money. Partnering, I'm on the left-hand side now, includes off-site senior management involvement. So the partnering session typically deals with the top decision makers of the project in participating in the kickoff session. With a dispute board, you don't often get the absolute senior managers. You'll usually get middle management, but not the executives from the so-called corner office, which you do in partnering. In partnering, it encourages working together on all matters. Again, project management issues, as well as disputes and claims. Whereas on the right-hand side, the dispute board is proactively identifying and solving potential claims, but it's focused on the claim, not necessarily management of the project as such. So to that point on the left-hand side, the partnering focuses more on process, not substantive outcomes. So whereas the dispute board is focused on substantive outcomes, meaning, is somebody entitled to something under the contract? Are they entitled to additional costs? Are they entitled to additional time? So if you go back to the left-hand column, the partnering facilitator doesn't offer opinions. The partnering facilitator is essentially almost like a negotiation coach or a process coach to help the parties work together to solve the problem. Going to the right-hand column, the DRB is giving advisory and formal recommendations. So it's producing a deliverable with a so-called opinion on what the outcome ought to be. Going back to the partnering facilitator does not propose an outcome, does not give an opinion, does not say who's right or wrong under the contract, whereas the DRB can do that. So how do you coordinate these two? Let's say you do have a major project where you're deciding to do both partnering and dispute review boards. So you have to recognize that they have separate roles and functions. And I tried to describe some of those. Partnering, very flexible, very broad, and very people focused. DRB looking more at the contractual arrangement, rights and responsibilities, outcomes of potential disputes, but they can complement each other. And what you need to understand is what are their respective roles and responsibilities. For example, partnering doesn't replace the DRB role in dispute avoidance because, again, although a partnering facilitator may assist in keeping disputes under control, that's not really their role per se, but it is the part of the DRB. So you're basically doing the same thing on different sides of the scale, so to speak. And partnering also could be used to assist in dispute resolution. And I mentioned Caltrans using facilitated dispute resolution. So you can see how the roles can go back and forth between the so-called columns of responsibility, but one needs to understand that a partnering facilitator has a certain responsibility and role, and a DRB has a certain responsibility and role, which need to be fit together. So what are some of the implementation considerations? What do you need to
Sorry,
think
Kurt.
about? Oh, yeah.
I wanted to jump in for a moment. If you can come back to the, not to the previous slide, but the previous one, the one that compares
two columns. Yep.
And dispute board. I think it would be interesting to see if Julio can share with us a little bit of his perspective here, because I think we are far enough in the presentation such that we kind of understand what partnering is and we can compare it to the dispute board, especially the dispute review board, which is more often the case in the US, whereby this board doesn't issue decisions. They're not an adjudication board, it's more a review, so they issue recommendations, which is different than a lot of times what we see. Well, I think in Latin America we see both, but more often than not, at least in my mind, in my experience, we see more and more the dispute adjudication board, such that they are offering decisions. Mm-hmm. So I'd like to see if Julio have anything to mention or to share with us in terms of how would that compare to a Latin American situation where we have more the adjudication board rather than the review boards.
Thank you, Felipe. It is very interesting what Kurt was presenting, because he gave us a very clear perspective about the missions, if we may say, of both instruments, both tools. And I would like to start, I think, with a comment regarding the importance of looking further to the reality or to the perception of reality that we have in relation to disputes. We are built in a framework that we believe that disputes should be decided and resolved in a way, I would say, in a very tragic way sometimes. So the construction industry had to develop means to bring back the parties to a situation where they could really rely on each other, and they could discuss, and they could look for a better way to solve their issues, their conflicts. The conflicts are inherent to any contract, not only construction, but in the construction contracts, the conflicts, they are there because they are always complex contracts. No matter what, we'll have several stakeholders involved, we will have several layers of participation, and then it's natural that we will face disputes. The problem is not that we have disputes or that we have conflicts, but also how we can avoid those conflicts, but much better, how we can prevent them. So in the history that Kurt presented to us, and also if we compare with the history of dispute boards, we see this quest for preventing conflicts since the early 60s. And initially, there was no, I would say, no a clear view about the structure of how dispute boards they should occur, or how dispute board should be. But the main idea was we have to create a level of trust. We have to bring the parts on board to develop this project in a way that they can share crucial information, that they can really identify and solve potential claims and conflicts, and focus on the outcomes, expected outcomes of the project. So when I think in Latin America, Felipe, you know this very well because you have a lot of experience, not only in Brazil, but also in several other countries in Latin America. The perception that we have the possibility to solve conflicts or even to prevent conflicts is new. I would say for many years, the parts, they only consider litigation as a means to solve disputes. Then we evolved to the adoption of arbitration, which is still a final resolution method. But then I would say in the last 20 years, we face the possibility to think about partnering, alliancing, and dispute board. Of course, we are talking about three different animals here, but alliance is I would say, is the outcome of this concept in the delivery method, specific delivery method that brings on board the partnering and also the dispute board instrument. But when we compare the adoption in Latin America of both, especially partnering and dispute boards, we see that more and more the parties are realizing how important it is to start the project with the mindset that we may have our difference, we'll try to solve our difference, we try to proactively identify the possibilities to solve those claims, because claims are not good for anyone. It's not good for the contractors, not good for the owners, and especially are not good for the financiers. And that's why in Latin America, Felipe, and this I'll head back to Kurt here, we have to emphasize the importance of the financiers, the lenders, especially World Bank, IFC, IADB, in promoting both concepts, partnering and especially dispute board. I think was with the view of the lenders that they really want the parts to get along well. They really want the parts to proactively identify the potential claims to be solved and how they could do this in a fast and less costly way. And the good outcomes of those contracts were important to also present to the other areas of the construction industry the importance to get on board on those two concepts. So I think initially I would like to make those comments. Kurt, please continue your very good presentation.
Okay, so Felipe, I'm going to...
Sorry, Kurt,
Yeah,
sorry to
ahead.
interrupt, because I did see we have some comments / questions already. So perhaps we can start sharing some of them with you as well, if you don't mind. There's one specifically, I guess one comment that I think would be interesting, because they're talking about what we just discussed, like the differences between Latin America and US. So the comment, not really a question, is contract law is key to have successful partnering in the US common law versus Latin American civil law. So perhaps you guys want to make some comments on that. And then if I can just throw there the next actual question, and then perhaps you can comment on both at once. It says, it's a question for both of you, in any case, specifically. And they say, A.V. Sharma says, for respectively Latin America and United States, what percentage of contracts, government ones, contain partnering clause in it?
So, Julio, do you want to start and then hand it over to me?
Yeah, no, I think those are very interesting points. First, I will start with the last one, Avi's comment and question. the reality is that in Latin America, administrative law that rules the government contracts is very much influenced by French law. So throughout the Latin America, the main concept was that the government could do anything. The le roi, c'est moi. So I'm the state, and I can do everything. This was there for many, many years. Was there in Brazil, in Argentina, Chile, Peru, Ecuador, and all countries, Colombia. So, and the challenge was to think in the evolution of this concept, how to make, although we are talking about a very regulated type of contract, although we know that everything that happens in a government contract, we may have audit courts and other stakeholders, sometimes even the public prosecutors involved or watching what happens there. Can we make an environment of partnering, or even create a way that the parts they can sit together and prevent conflicts? This was a taboo, I would say, for many years. But in the last 20 years, I could see the evolution of that, not only in Brazil, but also in other Latin American countries. And the concept of partnering, as was presented by Kurt, maybe we will not identify entirely this regulated in the contract, but we will see portions of that in the contract, especially stating that good faith is something important. So the relationship by the parties has to be based in a way that they can rely and trust their positions, their information, and so on. Also, with the adoption of dispute boards, and in Brazil, what happened was, and I imagine the same is happening now in several countries, but in Brazil, we needed to have a regulation that would say to the audit courts that dispute boards are legal and okay to be used by the government in their contracts. Not because they need it, but because the perception of that this different approach to solving disputes could conflict to the administrative law. And in the past 10 years, we had several demonstrations, several with statements by the judicial courts, also by the government, also by the audit courts, stating and recognizing dispute boards. And also, we also have in our administrative law a specific article dealing with dispute boards, accepting that the parts they have to come in a environment of trust. They can try to solve and prevent disputes, etc., etc. So, going back to Avi's question, I would say the pure concept of partnering, I would say we rarely see this structure in the government contract with all the information, but we will see pieces of that are important. And more, I would say it's becoming perhaps the default basis in government contracts. We are using dispute boards. So I think that's the tendency here. And in relation to contract law as the key to a successful partner, I think, of course, the baseline for the parties is very important. But I don't see much difference here between common law or Latin America in that regard, because what I see is that if the parts they have established the use of partnering or the use of dispute boards in a way that's detailed, that's clear, that we anticipate the outcomes, the initiatives of the parties, and we conduct the parts in that environment, I would say that both contract laws, they would confirm and they would really, I would say, affirm that partner is there, dispute boards are there, and they should be observed. Thank you. Kurt.
So to respond to both of the questions, the first one is the percentage of contracts. I don't have a statistic that says a percentage of contracts across the entire U.S. because every state has its own different contract regime and practices. But I'll use Caltrans, the California Department of Transportation, as an example. They do billions of dollars every year of highways, bridges, tunnels. They require partnering on every contract, literally every contract. They also require DRBs on every contract over $10 million. And the way they look at it is that partnering is like an umbrella of good project management in a collaborative, cooperative manner. Dispute resolution is one band within that umbrella. And that's where the DRB comes in. So if the umbrella relationship cannot resolve an issue or head off an issue, the safety mechanism is to file a dispute or a claim. And the DRB is the mechanism by which that can be more formally resolved within the contractual framework. So that's basically the view of Caltrans in terms of why do they do partnering and how does it fit over the dispute resolution process. Now, to talk about the question of civil versus common law versus bespoke contracts, they're all equally complicated, especially mega projects. They're equally complex. And you'll find in the United States that they can be equally draconian. They can allocate risk to the wrong party. They can be very strict on notice provisions, et cetera, et cetera. So partnering kind of softens the rough edges of the contract. You still have the provisions, and I mentioned right off at the very beginning of my presentation is partnering does not change the contract. It addresses how the contract is going to be implemented on the circumstances of a particular project. I'll use an example, the differing site condition clause. The differing site condition clause will contractually define the risk. But those who do projects know that that is defined in the field. Depends on what you did, what you encountered, etc. Partnering allows a dialogue around how are we going to implement what appears to be a clear contract provision in the realities of a particular project. So that's where partnering can bring in a overlay of implementing what the contract says or doesn't say. And to pick up on Julio's point about alliancing, alliancing is a contractual method of shared risk and reward. So the shared risk is baked in, is built into the contract. But that's very rare in the United States. It's really about risk allocation. And often it's the wrong risk allocation, which creates conflict. But partnering, as I said, softens the edges of how that gets implemented in the real world. So that was my response to the two questions, Felipe.
Thank you very much, Kurt. If I can make just a very brief comment and perhaps a dangerous simplification. When I look at partnering, and I know it has a lot of science behind it, and it obviously it's something very useful and works. It helps projects, complex projects, going through their difficulties. But to me, it looks like it is a third party doesn't need to be in the contract. It's a third party that helps the different parties of the contract to communicate and deal with the issues they have. Right? It has like a communication role that is oftentimes underestimated, and allows parties to go through their issues. Like, it opens up an arena for discussion, open and honest discussion about difficult things, just because they're difficult. These are complex projects, long-term projects with sometimes many contracts, sometimes different laws. So they have like international players. So, they can be very complicated, and having somebody who is focused and trained on making those different parties discuss their issues can be very helpful, I find. So this is kind of how I see it, and of course with all the science and management behind it.
So Felipe, I'm going to suggest I'll finish up with my slides here, and then we can
Yeah.
go back to see if there's any questions that need to go. So I'm going to quickly flash through to where we were. So there are some practical considerations for how do you actually implement partnering and DRBs on a project. So these are some of the things project teams or owner teams need to think about. First of all, there has to be a cost and budget for both processes. So you need to build into the budget enough to support both of these processes. Partnering facilitation is relatively small cost compared to the DRB, but it still is a consideration of if you're going to do both, you're going to have to pay for both. Typically, it's 50-50 split, though, with a contractor and owner. What's the timing and relationship of the processes? And by this, what I mean is, let's say you're going to have a partnering kickoff meeting shortly after the project gets up and running. You're also going to have a dispute review board kickoff meeting shortly after the project gets started. Should they be together? Should they be separate? How do you manage those? So those are things to think about in terms of, it's great to say we're going to do it, but the question is, how do we actually implement it in a timing manner and a sequence manner for making sure that the two processes work together and are not in conflict? Does the project team understand the different roles? Does the project team understand the project facilitator, partnering facilitator, has a certain role, certain ability to communicate, certain ability to intervene? And does the project team understand the role of the DRB, what they can do and what they can't do, and how that contrasts with the partnering facilitator? And then equally important, does the partnering facilitator and the DRB understand their respective roles? Does the DRB understand it's not there to do partnering? Does the partnering facilitator understand that he or she is not there to provide substantive opinions, as the DRB does? I'll give you one example. I'm on a project right now where I serve as the partnering facilitator, but I'm also serving as what's called the DRB administrator. So it's a dual role that the project team wanted to implement, where I do the partnering on this side, but I also have a dotted line to the DRB as administrator. Now, I don't get involved in the DRB disputes or tell them what to do, but I help manage what they do so it fits within the partnering framework. So that's just an example on a project where the two were put together in a very careful and considered way. So finally, DRBF resources. Obviously, the DRB manual, the dispute board manual of best practices is a general description. We do touch on partnering and the relationship between it. Also, there's a link here to 2 articles that I wrote about partnering in the United States. Essentially, they're articles that describe how does this all fit together. And then there's another one that describes how different agencies implement partnering and DRBs at the same time. There's some variety among different jurisdictions. They do it in different ways. And ideally, what we want people to think about is what way works best for our particular project. And that, Felipe, comes back to you to see if there's any questions that our audience has. Felipe, you're on mute.
Yeah, just found it out a little late. Thank you very much, Kurt. Very interesting. Thank you very much, Julio. We have some questions. Let's go ahead. But we did touch on most of the questions and comments, but I do want to go through additional questions that came through. I see by Engineer Oscar Cortes. He says, the DRBF was created by the American Association of Civil Engineers because of the need to improve better technically structured projects by reducing risk and encouraging a strict constructability review, which is lacking in Latin America, in my experience. Lacking in Latin America, in my experience. Can you comment on the project delivery process? I think Julio mentioned a little bit about it. If you can make some comments on it, please, both of you.
No, perfect. I can make some initial comments and then Kurt can go on. I think going back, we are talking about tools and instruments that can bring the parties to a more appropriate environment of preventing and solving disputes. And for that, we can have several tools, several techniques. Partnering is one very important technique, as was demonstrated by Kurt. The other technique is, of course, the adoption of dispute boards or dispute review or dispute adjudication. We always have the emphasis on having this since the inception of the contract, so the parts, they can really have the DB members following since the beginning what happens and giving positions or decisions or recommendations very fast in the best appropriate way. The use of other methods, I would say IPD, for example, they are also instruments that can help the parts to prepare and to advance in that, I would say, in that environment with a more specific approach towards the technical responsibilities of the parts. As Kurt very well established, partnering or dispute boards, they don't change the contract. They don't change the allocation of risks. They are there to help the parts to fully understand and to deal with those consequences of the allocation. But when we adopt process delivery, IPD, and even we can go further, for example, BIM, we are adopting instruments, BIM, we adopt instruments that give more transparency to the responsibilities of the parts in relation to the project itself. So I think it's an evolution, and the only concern, in going back to Oscar comments before the contract law, is that the parts have to be very clear about what they want. They have to really have an informed decision with the support of contract law. But in the contract has to be very clear about what should be done, how it should be done, the consequence, and so on. Sometimes the parts, they not only with those concepts, but with other concepts, the parts are not so clear. And then they get frustrated by not having all the instruments they could have in the contract. So it's important that they really say, this will be a contract where we'll have partnering. This will be a contract where we will put a lot of effort in the presence of DBs. This is a contract where we will value the use of BIM and BIM. This is a contract where we'll have IPD really implemented in a good way with this consequence, etc., etc. Kurt?
So Julio, yeah, let me comment. I want to use this constructability example. So let's say the contractor has successfully been awarded a project, and they have reviewed the project design, and they have a concern whether constructability reviews were done. So in the initial partnering session, remember, we talked about identifying risks and mitigation strategies. So in the partnering session, if I were the facilitator and somebody raised their hand and said, I'm concerned about whether the design has been reviewed for constructability, that's a risk that we have. And once we get out in the field and discover that, in fact, it's not constructible, that's going to cost us all a lot more money than if we try to decide how to deal with that now. So what could you do in the partnering facilitation session? You could say, let's have a group that gets together. Remember, I mentioned one of the things you could have is a little task force that's put together to say, okay, that area of the project where there's some concerns about it, let's get our designer of record, let's get the contractor together, and let's get an owner representative together and have them go do a constructability review of this particular aspect of the project and then bring it back to us. Keep in mind that the senior managers are sitting in this kickoff session. They are trying to manage risk. They are trying to manage risk before the risk is encountered. So that's an example where a good partnering session can focus on that issue, even though, yes, should it have been addressed pre-bid? It should have, but it wasn't. So you can use partnering to bring it to the table, get a solution, and deal with it before it actually becomes a potential dispute or a claim down the road.
Excellent, thank you. We have another. It's a comment that also can start a new discussion. It's not really too focused on partnering, but on dispute boards. That says, Oscar Cortez says, in the US, usually DRB members are construction experienced engineers for the most part. Things more talking about how the dispute boards are composed, like the members of the boards. That'll be perhaps interesting as well, Kurt. You can comment as well. What do you see in terms of who are acting, doing partnering? As I said, I don't even know, Julio. When it comes back to Julio, please let us know if you have seen partnering as such in Latin America, because I don't think I have, but can remember. But go on, Kurt. Please comment first.
No, I think Julio should answer that question, Felipe. I think it's a good one. I'm interested to hear the answer too.
Oh,
I have, I would say, experience with pure partnering in 2 contracts, in Brazil and one in Chile. And those 2 contracts, they had, I would say, the partnering was not established. The parts in both of them, they didn't know exactly what would do. They had the idea, they had the concept, but it was important that during the course of the contract, they kept the idea alive, and we were able to implement, or we were able to contribute to define how the partner should work during the course of the contract. It's not the ideal aspect, but at least since the beginning, they had the idea that they would have some key concepts. So what we did, we worked in those key concepts to build, in the beginning of the contract, some months later, the structure of this part, and work it very well. Those 2 contracts, they would say, one important aspect, both contracts had an international owner, employer, and the employer was very clear that this was something that they wanted to have in the contract. So I think this is a key element, not only for partnering, but also for DB, but also for any other different forms of preventing and solving conflicts, because it really is really important that the owners is on board, the owners understand, and they apply those concepts. But also, I had other experience.
Julio, sorry to interrupt, just so that we don't miss that, because from what you mentioned, there are international owners. I'm guessing they are private sector, right, as opposed to
private sector, not government contract. But also, Felipe and Kurt, we had several, and then the partner was involved in some alliancing contracts. We had, I would say, from 2006 to 2014, several alliances that were established in Brazil, in Argentina, in Chile, in Colombia, in Peru, and the consequence was that the parts, they had the alliance, they had the allocation of risks. Sometimes was not the ideal alliance allocation of risks type that we normally expect, but they had concepts of partnering inserted in those contracts. So that's why I see that the concept is there and is evolving because of those experiences.
Okay, and in regards to the composition of the members of who is doing partnering,
yeah,
and who is doing dispute boards?
Yeah, in Latin America, and I would say going back to what I said before, because in the beginning we had to demonstrate that dispute boards were legal, that dispute board was there, that we could use, we always tend to have at least one lawyer in the panel. So I would say the normal composition in Brazil, or I would say at least in the experience that I have in Latin America, is to have at least one lawyer and 2 engineers or 2 architects or 2 geologists in the project. Is not, of course, mandatory, but I would say this would be the tendency, inclusive for government contracts.
Thank you. And you, Kurt, did you wanna?
Well, I would say that the trend is in the direction of having at least one lawyer involved, as Julio mentioned. There's virtually no claim in the United States that does not have legal implications and does not involve what we call the front end of the documents as opposed to the back end of the documents, the front end being the legal terms and conditions, the back end being the technical specifications. And often most disputes have both elements. Legal, the contractual allocation of risk and language, and the technical specs for how the project actually going to get built. And so my experience, and I think the recommended best practice of the Dispute Resolution Board Foundation, is to have complementary skill sets for the particular project. And especially if you have more complicated projects, such as public-private partnerships or what's now called progressive design build in the United States. Those are complex contracts with many different players. And I think having, again, a complementary set of DRB members increases the likelihood that they're going to be able to do a better, more holistic job in giving good recommendations. I would say on the partnering side, the more complex the project and the more players you have, the more you need a partnering facilitator and the partnering umbrella, because you've got different interests, you've got different players, and you have different roles and responsibilities, all of which has to be meshed together under this concept of a partnering umbrella.
Yeah, very good. I'm all about complementary skills and multidisciplinarity. Very good. We have another question, and we do have 4 more minutes to go, 3 now. So we can answer that question and perhaps close after that. Please, both of you, if you can comment. So is it fair game for DRB panel members to ask the parties during the DRB quarterly meeting what they are talking about in partnering meetings as it relates to outstanding commercial issues, as well as claims and or notices of intent to claim?
Now, did you say, Felipe, in the partnering meeting or in the DRB meeting?
So they're asking if it is fair for the DRB panel members to ask the parties during the DRB quarterly meeting, so that's all DRB, what is being talked about during the partnering meetings. So can they ask during a DRB session, what are you guys discussing in the partnering meetings as it relates to claims and notices?
Okay, thank you for that clarification. My quick response was no, because there are 2 complementary but separate worlds. And an interesting example is on one of my projects, the partnering facilitator would sit in on the DRB meeting. And then as soon as the DRB left, they would have a partnering meeting. And the idea there was that they could partner whatever came up with the DRB. So there are variations out there, Felipe, where it's not necessarily blending the 2 together, which is what you were talking about, but instead coordinating the 2 so that one feeds into the other one and vice versa.
Yeah, thank you. That's very good. We have
I couldn't agree more. I couldn't agree more.
Okay, that's good enough. Well, that's a fascinating topic, and I think well, Julio said he has had 2 experiences. I mean, something I would want to consider it new, perhaps not new, but not enough developed or explored across Latin America. I think it's something we all should be looking into very carefully, and if it's working elsewhere, there's a reason for that. So thank you very much.
If you before you close, just one comment. Please. First, what we said was the partnering. I would say we have those less experience, but we will have a lot of DRBs in all over Latin America, and the result of that also was the creation of Region 4, as you already mentioned. But also, I would like to take this opportunity to invite everyone here to participate with us with the DRBF annual event, the big conference that we'll have in São Paulo at the end of May. So, and for sure, partnering will be one of the topics that will be discussed, the relationship with DBs. So it's good that we will have Kurt, it's good that we have you, but it's good to have everyone in our event in Sao Paulo as well.
Yeah, good points. Thank you, Julia. Good reminder. Yes, and Kurt, any final words?
Nope, I would say just go out there and partner, even if you don't have a formal partnering program.
Yeah, that sounds good. Okay, that was great. Thank you very much, guys. Thank you very much, Julio, Kurt,
Thank you.
for helping and hosting us. And please don't take a look at the program. We're gonna have another one next week, and it's gonna go like that until the first week of March. Thank you very much.
Thank you.
Very much.
Bye-bye.
Take care.